My name is Peter Spanos. I'm a labor and employment partner and attorney with Taylor English, and I'd like to talk to you today about the National Labor Relations Act and National Labor Relations Board. By way of introduction, I've been practicing labor and employment law, especially union-oriented and traditional labor law under the National Labor Relations Act for 47 years nationwide. And what is interesting to me is during that time, I've seldom seen as many changes as are occurring now, especially last year, under the National Labor Relations Act. My practice includes both for-profit and nonprofit industries, and it includes both traditional businesses and current businesses in current fields. So let's talk about some things that affect everyone, not just unionized companies, but companies that have employees of any kind. 2023 was a year of dramatic changes in federal labor relations law as administered by the National Labor Relations Board under the National Labor Relations Act. Even though these developments have been covered in the news, the significance of many of them is not readily apparent. And I think it would be helpful to do a retrospective for your business or your clients to understand what has happened and perhaps see a little bit about what might happen in the future. Because the long-time settled standards under the National Labor Relations Act for employees are changing, and those changes are very significant. So let's start with some things that affect everyone. As you may know, under the National Labor Relations Act, employees, that is people who are not involved in managing the enterprise or managing other employees, but who are basically doing work. But that is a very broad definition, as we'll see. Employees have the right under Section 7 of the National Labor Relations Act to not only join unions and to bargain collectively, but also to engage in concerted action for mutual aid and benefit. And that last part has been expanded a lot this year, along with a lot of changes in union election procedures. Those rights apply to employees of both union and non-union companies. And I'll tell you up front that the National Labor Relations Act, under its current administration, 3 Democrats, 2 Republicans, and a Democratic general counsel who comes from a labor relations background representing unions, their emphasis is to expand employee rights and to push the balance of employee rights against employers to new levels. We'll see more about that in a minute. So some of the most significant decisions. Let's start with the McLaren-McComb decision, which was issued by the NLRB early in 2023. In McLaren-McComb, the National Labor Relations Board took stock of severance agreements. Severance agreements with former employees or departing employees are very common, and they commonly include confidentiality and non-disparagement provisions. It's very routine, I can tell you from labor relations perspective, to, in a departing employee, have the employee promise not to disparage the company and to keep the agreement and other facts about the company confidential. This has an obvious benefit in ending the disputes that may have occurred with a former employee. However, the National Labor Relations Board in McLaren-McComb took a very strong stand against confidentiality and non-disparagement provisions in severance agreements, basically ruling that with very minor exceptions, employees cannot be asked to sign severance agreements that contain non-disparagement clauses or confidential information clauses. In fact, the board went so far to declare that it was an unfair labor practice even to just ask the employee or propose it, even if the employee would otherwise be amenable to it. You can't ask them, and even if you ask and even if they don't sign, it's still an unfair labor practice. So what this has done is it's caused a split in what companies can do with severance agreements. Severance agreements for supervisors the people who manage others or who adjust their grievances or who executives in charge of the enterprise, they can still have those clauses. But normal employees, those clauses would now be unfair labor practice charges. So, big change number one. Another big change is under an NLRB decision later in the year called Stericycle. The Stericycle decision considered whether or not company policies could be unfair labor practice charges if they restricted the exercise of Section 7 rights, including particularly the concerted activity rights. The NLRB and Stericycle took a very broad view of those Section 7 rights and determined that if an employee could regard a company policy as punishing, restricting, or forbidding them from engaging in mutual activities with other employees for their joint benefit, then the policy is illegal on its face. And it's presumed to be illegal, and then to defend the policy, the company must come back and actually provide evidence that the policy operates neutrally and does not inhibit employees from working together jointly against the employer and in their own interest. So the Stericycle decision has broad application. And what the Stericycle decision means, and the takeaway from this, is all employee handbooks need to be looked at again. And perhaps you've already done that because Stericycle was decided last year. But it's very important for companies to take a look at any part of an employee handbook that affects or governs employee speech or behavior, including such things as agreements not to disparage the company, confidentiality of investigations, privacy, and so forth. All of those policies need to be reviewed to ensure that they're not subject to an interpretation. What the NLRB is saying is if an employee comes to us and says, I feel like this policy restricts me, the NLRB will presume the policy is unlawful, and the burden goes to the employer to defend it. So, and it could be any kind of policy that affects speech. So another takeaway here is that in addition to reviewing policies, companies need to be very careful about enforcement of those policies in the future if they haven't been reviewed, because like all NLRB decisions, these new rulings are retroactive. So it's important to take a look at a policy before you apply it if it affects employee speech. Under Stericycle also, it's important to know that even some kinds of extreme and outrageous conduct, sometimes employees get angry, especially in industrial situations, manufacturing situations, and they'll want to curse out or otherwise attack verbally a supervisor or co-employee. Under Stericycle, policies that have blanket prohibitions on that kind of conduct might be facially illegal. And the NLRB would like to see employees having a greater ability to openly criticize their managers and even to use language, that heated language. There are comments in the decision that say the heated language in some contexts the board views as okay. So bear that in mind in terms of training your managers and supervisors. In addition to the developments in Stericycle and McLaren-McComb, the NLRB this past year, later in the year, has expanded what are protected concerted activities. Formerly, it was taken for granted that protected activities means concerns of employees, not supervisors, within the particular company or workplace. But in a recent decision, the American Federation decision, the NLRB has extended the protection of concerted activities to activities on behalf of employees who are outside the company. In other words, employees who are sympathetic with whatever issues might be going on with the employees of another company, they have a protected right to speech and action that supports the other company. You can see how this might affect a company like Starbucks, for example, where they have hundreds of union organizing attempts going on at multiple stores. Moving then to the NLRB's more traditional role. The actions of the NLRB during the past year and the anticipated ones for 2024 make it dramatically easier for unions to organize. The irony of that is that as elections have rolled on in the past couple of years, the size of the bargaining units that unions have sought to represent has greatly decreased. Unions have filed many more petitions for elections in the past couple of years than they did previously. For about 10 years or so, maybe longer, election petitions were declining. Now they're increasing. But they're not increasing with large numbers of employees, say 50, 60, 70, 80, 100 employees. The petitions are increasing for groups as small as 5 or 10 employees. 25 employees is a common number. So the unions have focused on smaller companies, and they've also focused on what are called micro units. Micro units is a concept that came up during the Obama administration. And what micro units are is that instead of the union having to say that it has majority support and therefore wants an election or bargain with the company, because they have majority support throughout the company and all the company employees, unions are able to isolate a particular department, a particular group of employees, a particular work location, or any other identifiable separate unit that has common interests and hold an election just in those. This obviously creates a camel's nose under the tent issue where a union might start out representing a handful of employees in a particular function of the company and then use that to spread. So the micro unit is a major development and leads to many more elections. With respect to elections, there's an important decision of the NLRB that was reached in August last year. And the consequences of that I don't think are that well known, but they should be known because there are traps here for the unwary. The decision is called CMEX. Traditionally, under the National Labor Relations Act, if a union wants to represent employees, it'll go out and gather what are called authorization cards. Authorization cards are literally simple 3x5 or 4x6 cards that say, I hereby sign, and I want the union to represent me. The union can take those cards to the company, and based on having a majority of the employees sign those cards, ask the company to bargain. That's long been permitted. But up until CMEX, the company could simply refuse to look at the cards or look at the cards and then decide, no, you don't have enough cards to bona fide represent a majority of employees at the company. And therefore, we have a doubt that you actually represent them, and we're not going to bargain with you. Well, CMEX turns that on its head. Under CMEX, if the union offers authorization cards, then the employer only has two limited choices. One is to accept the cards and bargain. The other is for the employer to file a petition for a union election. Previously, the union had to go to the NLRB with the authorization cards and argue that election should be held. They had a hearing, and then if they were correct, then the NLRB would direct a secret ballot election. Now, it's the company has to ask for it immediately after the union demands recognition. That's a major change. This will result in many more elections being ordered. In addition to that, CMEX also changes what happens in collective bargaining. Previously, if an employer bargains collectively and there's some stress with the union, and the union accuses an employer of an unfair labor practice, for example, let's say the union says that the employer threatened employees or made unlawful statements during the election campaigns, or unilaterally changed wages and working conditions that destabilized things for the election, things like that. Previously, if that happened, the NLRB would just declare a new election. Now, if the union wins even one unfair labor practice charge after unsuccessful collective bargaining, there's no second chance at an election. There's no rerun. The NLRB has said that it will declare the union the victor and order the company to bargain. So you see, CMEX really changes things from where they were. and gives the union a lot of power to compel the company to bargain and to compel the company to be ultra careful in its statements and actions at the risk of turning an election that the company wins into an election that the company loses. While we're on elections, we should also talk about some of the changes to election rules. Again, these started with the Obama administration, but they've accelerated as late as December of last year. Under current rules that were announced in December, if a union demands an election, the National Labor Relations Board has 8 days in which to decide whether to hold a hearing and grant the election or not grant the election. Well, what this means is when the union demands that the company bargain, or demands an election, the company only has 8 days to come up with a defense and go to a hearing. It's a great disadvantage because unions typically organize for months in advance, and they're well prepared. The company may be caught off guard. In addition to that, previously the company could submit written briefs on the issues to the NLRB as to whether an election should be held or not. Now no one is allowed to submit briefs. It's a live hearing, and the company cannot file written briefs. In addition to that, under the current rules, again in December, only 21 days at the maximum is allowed between the time that an election is declared and the time that the secret ballot election is held. Obviously, if the union has been working for months on organizing employees, and the employer has only 21 days to try to persuade the employees to not vote in favor of the union, the employer is at a serious disadvantage. It's almost like working with one hand tied behind your back. The takeaway here is that companies need to always be alert to organizing in large and small groups. If you combine the effect of micro units, the new election rules, which are sometimes called ambush election rules because they surprise the employer and put the employer in a very difficult time situation, and the rules in CMEX where the employer is at risk if it doesn't operate very simple campaigns and strictly avoid any unfair labor practice charges. Net result of all that is to really give the union an upper hand in elections and make it extremely difficult for the employer to communicate to employees the advantages of not having a union in the workplace. And there are many advantages. Historically, unions win about 50% of elections. This means that as often as not, employees don't want a union, even though they've been, the subject of traditional organizing efforts that are pretty effective. So in the future, companies need to be much more aware of the possibility of union organizing and, so to speak, need to keep their ear to the ground for the signs of union organizing. Things like employees suddenly having conversations in a private area, and when supervisors walk up, they scatter or act embarrassed or be quiet. Things like pamphlets and other communications in the workplace, things posted on bulletin boards, meetings, even including barbecues and social events outside the office. All those things may signal union activity, and the employer needs to be aware of all those things because there's very little time to respond once the union shifts into gear and asks for an election. The next biggest thing with NLRB developments interfaces with things going on in other contexts. You all may be aware that states and federal agencies are trying to redefine, and some states have redefined it quite dramatically, what the criteria are for independent contractors versus employees. Under the National Labor Relations Act, employees have the Section 7 rights and can form and join unions and bargain collectively, but independent contractors cannot. The current NLRB is very dedicated to the idea of restricting the number of working people who are independent contractors. And in a decision called Atlanta Opera, the NLRB has declared that to be an independent contractor, you have to really be an economically independent entity, that If you work for only one company, such as the people working for the opera, and if you are dependent on that company, if you don't work for other companies, if you have not made an investment in a business, and if you are providing services that are part of the mainstream work of the company, it's unlikely the NLRB will not consider you a bona fide independent contractor. So this also has been echoed in developments with other agencies as well. The general trend is to require increasingly that independent contractors be able to demonstrate that they have established a business in many of the same ways that an entrepreneur would establish a business, by making investments, by providing a part of a service or product to a company that is not part of their regular production, is not part of their mainstream activity, by demonstrating that they work for more than one company, by demonstrating they have independent identities, and by demonstrating that they're free from control as far as the methods and means. In the past, if a person was free from control, they could work for one company and still be considered an independent contractor. Those days are going to be numbered, especially under the National Labor Relations Act. So, one final thing with the NLRB that is about to take effect. This video is being done in February 2024. At the end of this month, the NLRB's new rules on joint employers, that is, when two companies that may be independent from a corporate or tax standpoint would be considered the same company for labor relations purposes. Joint employers typically are equally responsible for each other's unfair labor practices, as well as in other contexts for violations of Title VII or tax issues or whatever. Traditionally, each agency has its own definition of what is an independent contractor. The National Labor Relations Board has adopted a new test which goes into effect on February 26th, according to which if one company has any actual or potential or reserved control over another company, such as a contract that says that they can step in, or a corporate relationship such that they could exercise power through the board of directors or something like that of the other company, then they are considered joint employers. The big difference here is, instead of having to demonstrate that there is an actual joint employer relationship involving labor and employment relations between the two companies, now all the NLRB needs to determine that they are joint employers and responsible for each other's labor practices and must having to bargain with each other's employees. All you need to show is the potential that one company could control another, or reserved control. And that's going to sweep a lot of companies together that under previous law were not considered joint employers and could conduct independent labor relations. So, as you can see, a lot's gone on recently, and in the future, we can expect some other changes. The NLRB General Counsel still has sights on some targets, such as eliminating the ability of employers to give speeches to employees during an election campaign on working time, which would really make it hard for the company to communicate to employees if the company wants to demonstrate the advantages of not being union. As well as the NLRB probably wants to continue to expand what are protected concerted activities, perhaps even saying that efforts to do something that might affect supervisors, managers, and so forth are protected concerted activities, even though it's not within the original scope of the act. I talked about the activities at other companies that are now considered a part of that protection, and the NLRB has been working towards expanding the definition of employees into athletics and other contexts. So we can expect changes this year in 2024, that are equally significant. Well, I hope this has been helpful. It's kind of a rush through a lot of things, and I suppose that what I really want to communicate to everyone is change is occurring, and it's important that you have qualified counsel that keeps you abreast of these changes. And it's important that you spend some time working on your policies, especially in light of Stericycle and McLaren-McComb, working on your policies and practices to make sure you're not caught unawares. Again, my name is Peter Spanos. I'm a labor and employment partner at Taylor English. And if you go to taylorenglish.com, you can find all my contact information if you have questions about this presentation. Thank you very much.